Good afternoon, everyone. My name is Ilanka Manrique, and I am the research assistant at the TTMA. I will be assisting the EOC this afternoon, monitoring the Q&A tab, as well as introducing the presenter. So with no further ado, I'd like to welcome the Equal Opportunity Commission to deliver their presentation entitled Employment, Discrimination, and the EOC Know Your Rights. Your presenter this afternoon is Mr. Haran Ramkaran Singh, who is the Director of Legal Services at the Equal Opportunity Commission of Trinidad and Tobago. The Commission is a public body created by the Equal Opportunity Act with a mandate to work towards the elimination of certain types of discrimination. Among other things, it can receive, investigate, and conciliate complaints from members of the public who believe that they have been subjected to discrimination prohibited by the Act. Mr. Ramkaran Singh leads the Commission's legal unit, whose primary task is to investigate and manage complaints lodged with the Commission. He holds a Bachelor of Law degree with honors from the University of the West Indies, a legal education certificate from the Council of Legal Education, and an international master's in business administration from the Arthur Lockjack School of Business. Mr. Ramkaran Singh has previously been employed as the corporate legal officer in the Corporate Legal and Compliance Department of the Telecommunications Services of Trinidad and Tobago. He also held the role of a legal officer in the legal department of the Trinidad and Tobago Electricity Commission and a legal officer in the Chief State Solicitor's Department in the Ministry of the Attorney General. He was also a member of the Council of the Law Association of Trinidad and Tobago for 6 one-year terms. At these institutions, Mr. Ramkaran Singh gained a wealth of knowledge and experience in civil, high court litigation, trial advocacy, public law, and human rights, corporate governance, and regulatory compliance. I now invite Mr. Ramkaran Singh to begin his presentation.
Hi, good afternoon, everyone. Thank you, Ilanka, for that introduction. Yes, we are from the Equal Opportunity Commission. We did a slideshow, which we're hoping to share with you soon. You know, everyone is now using Zoom and all these technological platforms, and it takes a little while to get accustomed to it. If it is anyone out there has any questions during the presentation, I believe there is a chat box you can use to ask during the presentation. So, and if you ask, I will try to answer as much as possible during. At the end of it, there should be time for more Q&A and you know, perhaps those questions that I didn't answer, I'll try to answer then. But yes, so without further ado, I will get into the topic. We are from the Equal Opportunity Commission. I don't know, well, normally the sessions we do it live sessions where I would ask the person in the audience, what have you heard about the Commission? But you know, this is an online platform, so I guess I'll just go into what is the Equal Opportunity Commission. The Equal Opportunity Commission is a public body that was created by the Equal Opportunity Act of Trinidad and Tobago. Next slide, let me see. Sorry. Yes, I'm just working on the slides. It was created by the Equal Opportunity Act of Trinidad and Tobago, which is an act of parliament. Now, that act was passed to prohibit certain kinds of discrimination and to create a mechanism for which persons who have been subjected to that discrimination can get redress. The act created 2 institutions, that is the Commission and the Tribunal. The thinking behind the act is that certain kinds of discrimination from henceforth will be prohibited in Trinidad and Tobago. And if you have been subjected to that, you can go to the Commission, you can come to us via the Commission and lodge a complaint. We are mandated to receive the complaint, investigate it, and where possible, to conciliate the complaint. That is, we bring parties to the table to have a discussion to see if it can be resolved. If it cannot be resolved, the Act created a second institution, that is the Equal Opportunity Tribunal, and they are a court. Just like, you know, the High Court or the Industrial Court, they are chaired by a judge, and their remit is to hear and determine the complaint that's not been resolved. I always like to draw the parallel with the Ministry of Labor and the Industrial Court in the sense that if you have a trade dispute, you report the trade dispute first to the Ministry of Labor. They conciliate the dispute. They don't investigate those. So in that way, we are different. We have powers of investigation. We can investigate the complaint. The Ministry of Labor generally doesn't. They just simply try to conciliate. And then if it cannot be resolved, then it goes to the Industrial Court. They certify it as unresolved and send it to the court. And so it is a sort of a similar parallel that exists here in that you come to the Commission first with your complaint. If it cannot be resolved, then it goes to the Tribunal. But apart from the complaint handling mechanism, we have other proactive duties that we do. For example, one of our duties is to work towards the elimination of discrimination. Another duty we have under the Act is to engage in public education and advocacy. So for example, what I'm doing right now is a form of our public education mandate, where we inform the public and we do training programs with members of the public. In fact, we do training programs on request, free of charge to many organizations and many institutions. So for example, if you are watching right now and you feel that your organization, if you're from a Chamber of Commerce, we have done for regional corporations, Rotary clubs, that sort of thing. So if you feel that your club would benefit from a training session with us, or however long or however short you want it to be, then you can request that we come in and do that. So yes, yes, we do public education, we do advocacy, we prepare and publish guidelines. That's one of our given mandates. And during the course of this presentation, I will come to the guidelines that we have published. And just to indicate, those guidelines are available on our website and can be downloaded free of charge. Yes, I'm having a bit of a challenge looking with the slides. Next slide, please. So the Act was passed to prohibit certain kinds of discrimination, but the Act was passed in 2000, but it wasn't until 2007 when a matter went to the Privy Council. And interestingly, the person who took that matter to Privy Council was Mr. Kenneth Surratt, and just recently, Her Excellency the President appointed a new Board of Commissioners in October of this year, just a few weeks ago, and Mr. Kenneth Surratt is now one of our commissioners. Now, in the 2000s, Mr. Kenneth Surratt took a matter all through the High Court, the Court of Appeal, and the Privy Council, and it was Baroness Hale of the Privy Council of the Supreme Court of England ordered the government of the day to implement the Equal Opportunity Act. And so following upon that 2007 judgment, it was only thereafter that the government of the day took the steps to set up the commission, to set up the tribunal. So both the commission and the tribunal have only been in operation for the last 10 years or so, despite the Act being passed in 2000. And that gives you a bit of a background as to the commission, who we are and what we do. Now I'm going to go into what constitutes discrimination under the Equal Opportunity Act. Well, I'm sorry, yes, this is our, you can go through the slide. This is our vision statement and our mission statement. This is what we envisage. Again, all of this you can get on our website if you were to go and look at our website, www.eoc.gov.tt. If I were to use this, I'd get rid of these slides. Yeah. Yes, I think this might be better for me. All right, so the next slide, okay, it's not looking. All right, the next slide will, we're now going into, sorry, just one little technological issues. The next slide, we're going now into the area of what constitutes discrimination under the Equal Opportunity Act. Now the Commission's jurisdiction, the Equal Opportunity Act, you remember that I had said that the Act was passed to prohibit discrimination in certain kinds of areas. So the Act applies to discrimination in 4 broad categories. And you're seeing it there. It applies to discrimination in employment, in education, the provision of goods and services, and the provision of accommodation. But that discrimination must be on what is called a status ground. And you can think about it logically. What are the grounds on which people claim to be discriminated against? For example, and this is a standard question you ask, and people would say, well, I could be discriminated based on my race, and that's correct, your religion, your ethnicity. People raised that they could be discriminated against on their age, and that is correct, but we'll have to stick a pin on age. And also sexual orientation. People can be discriminated based on their actual or perceived sexual orientation, but we need to stick a pin there. And I said stick a pin on age and sexual orientation because while these may be grounds on which people are genuinely discriminated against, the Equal Opportunity Act only applies to certain kinds of discrimination and at present does not include age, that is how old you are, and sexual orientation. One of the Commission's other mandates is to make recommendations for amendments to the Equal Opportunity Act, and we have recommended to the Attorney General that age and sexual orientation be added as status grounds for protection. But at present, the status grounds that are protected are, as we had mentioned, race, we had mentioned ethnicity, your sex, your religion, your disability, your marital status. Those are the grounds that are protected under the Equal Opportunity Act. So what the Act is concerned about really is where someone is complaining that they're being discriminated in their employment, but that discrimination is because of your race or your disability or your religion or your ethnicity or that sort of thing. There's another ground on which people can complain, and that ground is known as victimization. Now, victimization really applies to where someone has tried to enforce their rights under the Equal Opportunity Act and they are now being adversely treated. So let us say you have lodged a complaint with the commission, and having lodged a complaint, I'm just using a hypothetical situation, you lodge a complaint against your employer, and now having lodged that complaint, you're now seeing that you're being treated unfairly or unfavorably in certain ways. You're being, for example, your parking spot has been taken away from you. You were denied being attendance at some training seminars, a conference. You're denied a promotion, that sort of thing. Then you can lodge a second complaint known as of victimization. That is where you're saying that having lodged this first complaint, I am now being victimized. So the protection against victimization doesn't apply only to those who lodged a complaint. But for example, if you are giving evidence or in favor of a co-worker who has lodged a complaint, or you've indicated that you intend to do so, or even if you've simply written a letter or an email and you've alleged discrimination, that is, and a lot of our complaints of victimization stem from that basis, where they would have written a letter or an email or something of that sort to their manager, their supervisor, their boss, in which they allege that they're being discriminated against, and following upon that email or that letter, they're now alleging that they've received less favorable treatment. Then that could be a second complaint of victimization. And there's a third standalone area that the Act is concerned about, known as offensive behavior. The corollary to offensive behavior is what, for want of a better word, you'll refer to as hate speech. That is, offensive behavior applies to anything that is said and done in a public space. And the Act uses the word in a public space or in the public domain. So for example, if you say and do something in the privacy of your home, but you record it on a video and you post it on YouTube or you post it on Facebook, then that takes it into the public domain or in a public space. Or similarly, if you go into a radio station or a TV station and you say things that are broadcast on the airwaves, then although you can say, well, I said it in the privacy of the TV station, but you said it in a studio with the intention of it being broadcast and it was broadcast. So again, that takes it into the public space. So if you say or do things in the public space that incites hatred or contempt towards other persons or groups of persons based on their religion, their race, their ethnicity, their gender, then persons from that group can lodge a complaint of offensive behavior. I'll come to these areas in a little bit. Now, the focus of this discussion this afternoon is on employment. So I just want to go into what is employment under the Equal Opportunity Act. Normally, when you speak to an attorney, they will tell you about things like a contract of service or contract for services, a master and servant, an independent contractor. These are words that lawyers tend to use. Just to go on a sidetrack, if you go to the industrial court, you will hear a discussion, is this person a worker or not a worker, that sort of thing. The Equal Opportunity Act is not constrained by any of these notions. So for example, if you look at the slide, employment means employment under contract of service or apprenticeship or contract personally to execute any work or labor, and includes the employment of an independent contractor. So in other words, what the Equal Opportunity Act is intended to do, it is intended to give protection to all forms of employment relationships. So you can't simply say, well, I'm prohibited from discriminating against a person who's a worker under the Industrial Relations Act. But if you're not a worker, for example, if you're a teacher or you're a manager, which is, if you're familiar with industrial relations law, persons like that are not workers, I can discriminate against them. No, that's not what the Equal Opportunity Act says. So maybe for the purposes of the industrial court, you will have that discussion, is a person a worker or not? Or if you go to the High Court, you will have the discussion, is a person an independent contractor or servant? But for the purposes of a complaint under the Equal Opportunity Act, as long as there is some form of employment relationship between yourself and the other person, then that person can complain about discrimination in employment. What we will come to under the categories of discrimination in employment, you will see one of the grounds for discrimination in employment is refusing to hire somebody. And now, technically speaking, if I don't hire you, you are not my worker, you are not my employee. So that technically speaking, a person like that cannot bring under ordinary law, that is to say, the law that applies to the High Court or the Industrial Court, that person may not be able to bring a claim because there's no employment relationship. And more often than not, this is sometimes where a lot of discrimination takes place, that a person is not hired because of some reason relating to their race, their sex, their religion, their origin. just to digress, for example, the origin means where you come from. We have had a situation where someone has lodged a complaint saying they were not hired or they were not allowed access to goods and services because of who their father was. So I'm just throwing this out for you that, these are areas in which people claim discrimination. And it could be that sometimes the discrimination takes place in not hiring the person. And so the Equal Opportunity Act applies to, for example, hiring practices. That is your relationship with your prospective employees, people you may or may not hire. Then your relations with your existing employees. And finally, relations with your candidates who are undergoing training or apprenticeship. Because again, technically, if you were to apply what is called the common law, a person who is an apprentice or a trainee may not be an employee. But for the purposes of the Equal Opportunity Act, any employment relationship is covered by the Equal Opportunity Act. So what are you looking at when we say hiring practices? Are you saying I don't want to hire this person because of their sex? Or are you saying I will hire this person, but I will pay them a lesser salary than I'm paying a person who is in the same post? Now, simply saying I will pay a lesser salary by itself may not be discrimination if you can justify it having regard to things like the person's qualifications, the person's experience, and conversely, when I say I'm paying this person a higher salary, I'm willing to pay them a premium because they bring something to bear to my organization. What the Equal Opportunity Act is concerned about is hiring on discriminatory reasons. I'm saying I'm going to pay you more because I like you because we go to the same church, or we come from the same area, our geographical origin, or you're saying I want to pay you less because you are a single person. Again, you're discriminating against them because of their marital status. So a rule of thumb is that if you're making decisions with respect to employment, as long as you can justify it by reason of meritocracy, that is to say, the person's qualifications, their training, their experience, their track record, then that would be fine. What you want to avoid doing is relying on these what you call protected characteristics, relying on their disability, saying that I will hire this person, but I will pay them less because they present with a disability. And now, as I said, that's talking about hiring. We also can talk about your relations with your existing employees. Who do you decide to promote? Who do you decide to transfer? And the Act, these are tangible benefits, but the Act also looks at what are called benefits or facilities associated with employment, which may or may not be tangible. A simple thing like saying, who are you going to give a laptop to, or a cell phone to, mobile phones, anything that you may think that may not necessarily have a tangible benefit, the bigger office, the office with the window. Again, these decisions should not be based on these sorts of these protected characteristics, your race, your religion, your sex, that sort of thing. And similarly, relations with candidates undergoing training and apprenticeship. Who you decide to keep, who you decide to promote at the end of the day, who you decide to give a favorable reference to, a favorable report. So we have published, and we will come to that later, guidelines for employers in Trinidad and Tobago on how to avoid discrimination. Again, that is available for free or for charge for download, on our website, so you can go there and get more information if you want. As I said, the Act applies to 4 broad categories: employment, education, the provision of goods and services, and the provision of accommodation. I'm just very briefly going to touch on the other 3 areas because our focus really is on employment, but I'm just going to touch on it so that, just for your general knowledge, you're aware of it, because this may be relevant to you in some other setting, but it will also be relevant to you as an employer, because quite apart from the organization that you work for, maybe you may be an employer in that you employ people to do the work that's required, but your organization provides some sort of goods, services, facilities, or benefits to the public at large. So that as an organization, you would need to be aware of the Equal Opportunity Act, how it impacts you as an employer, but you also would need to be aware of it, how it impacts you in terms of what you sell or what you deliver to the public at large. So that at the very least, the provision of goods and services may be of relevance to employers and manufacturers. And if you look at this slide, examples of facilities, goods and services would be things like access and use of a public place, accommodation in a hotel or a guest house, banking, insurance, loans, finance, entertainment, recreation or refreshment. And it is important to, if the facility of any profession, trade, statutory, or municipal authority, it is important, if I didn't mention it before, to point out that the Equal Opportunity Act applies to both the private sector and the public sector. So for example, whereas the services offered by a statutory or municipal authority would fall under the public sector, the facilities of banking, insurance, loans, and finance, that is for the most part dominated by the private sector. Facilities for entertainment, recreational refreshment. So you know, it's something for you to think about. Does your organization, for example, fall into any one of these categories? Are you in the banking, insurance, or loans, finance, you know, that industry? Are you a professional? I mean, for example, the services of any professional, whether you're a doctor or a lawyer, and you have an office on the main road or something like that, then you could be subject, then not you could be, but you are subjected, sorry, to the Equal Opportunity Act. So how do you decide if you're, I'm just throwing this out as an example, if you're a doctor, how do you decide, what services you provide, or what fees do you charge? Are you going to say, I'm going to charge higher fees to certain persons who present with certain characteristics? You know, if you do, then you could be subject to a complaint under the Equal Opportunity Act. And an example of discrimination in the provision of goods and services, so the Act says, by refusing to provide the services, goods, or to perform the services, on the terms in which you supply the goods, you provide the facilities or perform the services, or in the manner in which you provide these services or facilities. So, you know, we used to do seminars like this for a lot of regional corporations, and they had asked us a lot of questions about this area, because if you think about the access and use of a public place, many of these regional corporations have within their burgesses parks and public facilities. And they were just asking us questions. Well, if they say that a person who from within their burgess wants to rent or get use of that park, they will get it at a reduced price from someone who's outside of that area. Just to give you an example, I'm just making this example, but for illustrative purposes, we are right here in Chaguanas and State Park is right next to us. So let us take the example of saying the Borough Corporation saying residents of Chaguanas can access State Park at a cheaper price. But if, for example, you are from Sangre Grande or Rima, you have to pay a higher price, or you have to meet other thresholds or what have you, then that by itself could be discrimination if the only characteristic that defines you, or the only reason for that differential treatment, is your origin. Now, if on the other hand, they were to say that persons, you know, if you have less than 10 people, you may get it free. If you have over 100 people, you have to have fire service clearance and all EMA clearances and what have you, then that would not be discrimination, because you are not treating with a person because of their origin or their race or their character or their ethnicity or their religion. You are treating with them because of a predetermined characteristic that applies equally to all persons, you know. And so that is based on the merits, for want of a better word, of that application. And if it's a large group of people, you have to meet certain other thresholds. So that's just something to think about with respect to the provision of goods and services. The Act also applies to the provision of, what's next? The provision of education. And again, it's important to remember that the Act applies to both the public sector and the private sector. So it's not just what we will call schools that are operated or managed or financed by the government. It's not just the primary schools and secondary schools, to put it in very colloquial language, but it could be any private institution. It could be any private tertiary, any private secondary school. What the Act is concerned about is, again, whether you fail or refuse to accept a student's application on the terms in which you admit them, or do you deny the student access to any benefits or facilities, or do you expel them or subject them to detriment? Again, now if you, for example, do not accept a student's admissions because of the grades that they have, then by itself that would not be discrimination or based on any of these characteristics. What we are looking at is discrimination based on your race, your ethnicity, your marital status, your disability, your origin. So if you're saying that, for example, now the Act actually makes an exception for what is known as the Concordat. So under the Concordat, you know, many of the schools that fall under religious denominational board, they have certain privileges, you know, vested in them. For example, you have in the SCA, they have what is called the 20%, where they can choose who they want to enter their school. The Act makes a specific exception for that, so that and the Act also makes a specific exception for what is known as single-sex schools. You know, so that many of our secondary schools traditionally, well, at least secondary schools that fall under the denominational boards are traditionally either all boys schools or all girls schools. So that, again, using an example from right here in Sheboygan, where we're based, a female student would not be able to lodge an application and say that they're being denied admission into Presentation College because the Act makes an exception for that. And similarly, again, using Presentation College just as an example to illustrate, a person whose child did not get in through the, kind of say that, the principal in choosing at 20% chose someone based on their religion and based on what have you, because again, the Act makes an exception for that. But quite apart from that exception, a school is not allowed to discriminate against students by denying admission based solely on characteristics such as race or ethnicity or religion and that sort of thing. And for example, I'm just going to say I remember we had a complaint a number of years ago against a secondary school that did not admit someone to do, well, what I call it A-levels. I know it's not, in my time it was O-levels and A-levels. She was not admitted to do CAPE, I think it is. And they're saying that they were being discriminated against based on, I think it was they had alleged religion and they had alleged disability. So I'm just using that as an example to show you what the Act is concerned about when you talk about discrimination in education. And yes, and finally, the Act is concerned about discrimination in accommodation. And it says that a person shall not discriminate against another person on the terms in which he offers accommodation, by refusing an application or by deferring an application or treating it a lower order precedence. Right now, for example, we're dealing with a complaint. I'm just to share with you, someone said that they called a real estate company that advertised a property for rent, and they were told that this is what they've alleged, that because they were from another country, they would not be allowed access, or they would not be granted a lease of the property because the landlord did not wish to rent to foreigners. Taking that allegation at face value, again, that the complaint has to be investigated. We have to hear the other side. I'm just using it as an example to show what kind of conduct the Act is concerned about. Because taking that at face value, that would be discrimination in the provision of accommodation based on origin. In that case, the person was a St. Lucia national and held a CSMA certificate. Now, if you're in the country illegally, it is possible that a landlord might say, well, I don't wish to rent to someone who's here illegally. And I don't think we have never had a case of that nature, but I would speculate that a complaint like that may not be held up in the long run because the landlord is not discriminating against you because you're a foreigner, but is discriminating against you, or rather refusing you because of your legal status. But going back to the complaint that we received a few weeks ago, that person was here legally being a CSMA skilled national. Because right now we know there's a lot of discussion in the national. There's a lot of national discussion about persons who may or may not be here legally from South America. So it's just something to think about. This was actually something. If you're looking at the web at our slideshow, this is actually something that came to us on Facebook. Somebody asked a question: 2-bedroom, Pfizer AC, East Indian couple, $2,500, and these are the phone numbers. Does the EOC address this sort of issue? You will remember now, I had mentioned when we were going through education that there were certain exceptions for education. There are also certain exceptions for accommodation. And one of the exceptions is if the premises is where the owner resides. For example, it is common in many areas where the owner might, say, build a 2-story house, the owner lives upstairs and has an apartment to do downstairs. So in that case, the owner resides there. The Act actually makes an exception for that, so that the owner can, for want of a better word, pick and choose who they want to live in what is essentially their house. It's an apartment in their house. It is something that some people may agree with it, some people may not agree with it, but it is what it is. So going back to this example of the 2-bedroom Pfizer situation, we cannot simply, while on its face it would appear to be discriminatory, and it is safe to say that yes, it is discriminatory. However, it may fall under one of the exceptions under the Equal Opportunity Act if it is that this premises in question is premises where the owner resides. Yes, so now having explained the 4 broad categories, I'm now just going to go into status. Both race and ethnicity are statuses under the Equal Opportunity Act, and people always tend to ask, well, in ordinary speech we use the words race and ethnicity interchangeably, but there's actually a difference between them. Well, I only learned this when I started working with the Equal Opportunity Commission, because I guess it's part of the jargon. But race is based on the biological or physiological characteristics that define different groups, whereas ethnicity is seen as a social and a cultural construct. An example I would like to use with respect to race or ethnicity: all persons from West Africa would be, or whose ancestors originally who are ancestrally from West Africa, sorry, would be of the African race. But persons might ethnically identify along different tribes. You might have the Igbo tribe, the Mandingo tribe, different tribes along West Africa. What distinguishes these tribes are their cultural practices, their traditions, their modes of dress. For example, women of one tribe may have a different type of head tie to women of other tribes. They may follow different rituals. They may, rituals related to birth, death, marriage, these sort of things. So all, different types of clothes that they wear. So all of these are what defines ethnicity as opposed to race. It is based on things like language, on cultural traditions, on culinary traditions, that sort of thing. Again, using an example from Europe, all persons from Western Europe would be of the Caucasian race, but you might have persons identifying ethnically as being French, as being Italian, as being German. A person who's French will have a different name than a person who's German. They speak a different language. They have different culinary traditions, that sort of thing. So that's just some general food for thought on the difference between race and ethnicity, because most people who complain to us about race, we have our complaint form invites you to tick boxes as to what you are complaining about. They always tick both race and ethnicity. Religion, it speaks for itself. It speaks to the worship of a supreme being or divine entity. It is not necessary to say to ground for your religious belief to necessarily adhere to the general belief of other people in the religion. In other words, some people have complained that so and so is genuinely, I'm just using this as an example, so and so is genuinely not a Catholic because they believe something differently to us. And if you come to us and complain that you're being discriminated against your religion, it is not our remit or mandate to inquire into what are the doctrinal beliefs and whether you are orthodox or non-orthodox or that sort of thing. Discrimination on the basis of religion really speaks to discrimination based on your personal, on a characteristic that's personal to you. In the sense that one's race and one's ethnicity are personal characteristics. One's religious beliefs are also a deeply held personal characteristic. And it's not necessarily for us to say, well, your beliefs are right or your beliefs are wrong. A question we had received, again, on our Facebook page is atheism covered under the scope of discrimination by religion? And this is a gray area. Legislation in other countries that provide for equal opportunity expressly say religion includes non-religions. For example, the lack of a religious belief. Because if you think about it logically, if someone is being protected, the Equal Opportunity Act protects you based on the beliefs that you hold and based on how you perceive God. And if for whatever reason you perceive God as being non-existent, which is, I guess, atheism or agnosticism and that sort of thing, then you should be equally protected as a person who perceives God in whatever form. So that's an issue that we've never received a complaint on atheism, but it would be interesting to see if we do, how it is handled. Now, again, one of the status grounds I had mentioned was origin. Origin includes geographical origin, but origin refers to the point at which you start. So it can include things as we have interpreted it to mean ancestry or parentage. I gave the example, I believe, a little while ago, someone who lodged a complaint with us who said that they were denied participation in an event because they were told that, because of who your father is, we don't want you here. Well, again, that's their allegation. I mean, I'm not saying that when I'm presenting this usually, I'm just throwing this out for discussion. I'm not saying that we agree with the person's allegations or not. Whenever an allegation comes to us, we have to investigate it, and when we do so impartially. I'm just presenting this to you just to illustrate what sort of complaints or what sort of matters we treat with. So origin, if that person says they're being discriminated against because of their parentage or their ancestry, then that, in our interpretation, that would be discrimination based on their origin. But origin includes geographical origin. So the person who said they were discriminated against because they were from St. Lucia, that would be discrimination based on origin. But it includes geographical origin, and it doesn't have to be international origin in the form of St. Lucia. And I say this because many times we hear in Trinidad and Tobago that persons who are from certain geographical areas within Trinidad and Tobago feel that if they disclose their origin, their geographical origin, they may be discriminated against. Persons who come from what have, for better or for worse, been termed as a crime hotspots. So that's something for you to think about in your organization. Will you treat with someone differently because you hear or you were told or you discover that they originate from one of these areas? On the other hand, on the flip side, we have actually had companies that told us that they only choose to hire persons from certain areas for the simple reason that these areas are geographically close to their factory. And let's use an example. And again, this is just a made-up example. If your factory is based in, say, San Juan, they're saying that they would want to hire people from close to that area as opposed to someone from, say, Cuba or Sangre Grande, because they believe that that person will be able to get there on time. And again, now that would also be discrimination on the basis of geographical origin, because you are making presuppositions about that person. What, as an employer, you would need to do, and this is what we told them, well, whoever they were, I'm just using the San Juan company as a made-up example. What we told them is that when you are hiring persons, you need to explain to them that what we require from you is X, Y, Z. We require you to be at our factory floor at 7 a.m. in the morning, and this is what is required of you, and it's up to the person to meet those requirements, as opposed to you presupposing that, again, using this example that I've made up, presupposing that because they're from Cuba or from Sangre Grande or from San Fernando, they would not be able to meet that requirement. And if you do hire the person from San Fernando and they're unable to meet that requirement, then you would have to use the progressive industrial relations steps to treat with this non-compliance. Yes, and that's origin. Additional to origin, one of our status grounds is marital status. Marital status refers to being single, being married and living separately from one spouse, being widowed or being divorced. Interestingly, it did not include cohabitees under the Cohabitational Relations Act. And as I had mentioned earlier, one of the Commission's mandates is to propose amendments to the EOA. We have also, and I said we propose adding age as a status ground. We propose adding sexual orientation as a status ground. We've also proposed to this section adding cohabitees under the Cohabitational Relations Act as a status ground. So now going back to marital status, I mean, are you treating an employee differently because you think they're married, and because you think, given that they're married or they have children, that they will not be able to meet the requirements of a job? So this is what the Equal Opportunity Act is designed to protect against someone saying that, because of the employer making these stereotypical assumptions or presuppositions. But again, it also works on the flip side. We had done training for one organization, which I wouldn't mention, but according to the policies of their organization, persons who are married received a bonus in pay, because it was felt, based on the nature of that organization and what they do, that they project a married man. It was to be perfectly blunt, it was a military type organization, and there's only one military in Trinidad and Tobago. They felt that a married person projected the image of an officer and a gentleman, which is something common in the jargon of military speak. And we have said to them that that's something you would need to reconsider, perhaps, because that could be that could run afoul of the Equal Opportunity Act if you're saying that you're paying a married soldier or married man or married person, whether male or female, a higher salary or premium or an inducement or an allowance. Now, if it is an allowance, it is possible. I'm not saying it's possible because, again, only when a complaint comes to us and it's investigated, and perhaps when it goes to the tribunal, to the judge, it can be adjudicated upon. So what I'm saying is possible is really my speculation here. It's not to be taken as a definitive statement that it is acceptable. It's possible that if you fit it in as some sort of an allowance, maybe it might, it could be acceptable. But again, it will have to be tested through a complaint being lodged and being taken to the tribunal. But it's just something to think about. Does your organization pay married persons a higher salary to a person who is single for doing the exact same job, and that is the baseline you have to come to. If the married person is working in a higher job or a different job, then that would be different. But if the married person and the single person are doing the same job, then they really, and you pay one a different salary to the other, and then that by itself could be discrimination under the Equal Opportunity Act. Now, I had mentioned sex as a status ground, and I had also mentioned we had recommended an amendment to include sexual orientation, and sometimes persons ask the question, well, aren't those two related? The short answer is no. Sex really refers to the biological and physiological characteristics that define male and female. Sorry. To put it very simply, sex discrimination is really differential treatment between men and women. Is a man being paid a higher salary for doing the same job? In the United Kingdom, there was a case where if the retirement policy of a company allowed a woman to retire at the age of 60, but did not allow a man to retire at that age. A man had to work until 65 in order to get the same retirement benefits and pension and gratuity and what have you. So I'm just throwing this out to you that it's not only women who may be discriminated against, but it could also be men, and that was held to be discriminatory. Recently in the United States, you would have seen that one of the Supreme Court justices, Justice Ruth Bader Ginsburg, had passed on. It was said that one of the very first cases in the 1970s that she argued before the US Supreme Court, that's when she was a lawyer, before she was a judge, she was only made a judge in the 1990s, was a case of sex discrimination. She was actually an advocate for sex discrimination, but some of the cases that she took were really sex discrimination that were meted out to men rather than to women. So again, it's just some food for thought that discrimination on the basis of sex does not, while it has traditionally been that the women are the ones who are more discriminated against, it's not automatically that women are the only sex that will be discriminated against. So that, again, using the example of differential retirement ages. Now, actually, but there are three biological sexes. I said that there's male and there's female, but there's intersex, which is a biological condition. It is where a person presents with the sexual organs or sexual characteristics of both male and female. It is a medical condition, or a medical state rather, not a condition. It's a medical status that doctors will have certain, criteria that they apply to determine whether someone is male or female and that sort of thing. And this slide just gives you an idea of natal sex, which is the sex one is born with, sexual orientation, and gender. You would recall earlier I had spoken about the difference between race and ethnicity. The difference, I said one is biological, whereas one is cultural. The difference between sex and gender is also the same. People, just like how people use the words race and ethnicity interchangeably, people tend to use the word sex and gender interchangeably, but really and truly they are different. Sex, as I said, is biological, whether you're dealing with male or female, whereas gender is cultural and it speaks to the words masculine and feminine. So, for example, you would have, a masculine clothing, that sort of thing. Yes, and this is sex and gender. And one of our main areas is disability. And disability means a total or partial loss of a bodily function or part of the body, a malfunction of part of the body, including a mental or psychological disease, a malformation or disfigurement. What is interesting about this definition, when we go to organizations and we ask about how do you treat, your policy or your programs with respect to disabled persons, or persons with disability rather, they will tell us, well, we have accessible bathrooms, we have wheelchair ramps and that sort of thing. But then we would ask, well, how then, let's throw some food for thought. How do you treat with a person who presents, for example, with a psychological condition, like if they present with paranoid schizophrenia, bipolar disorder, because those are also disabilities as well. It is what you call the hidden disabilities, because you don't see it physically, but it is also a disability, a person who has a psychological disease or disorder. According to Professor Jared Hutchinson, while the burden of stigma falls on those with mental health problems, it is created by the attitudes of the wider society. It has been theorized that stigma against others is created to reaffirm one's own preferred identity. 1 in 4 persons in Trinidad and Tobago is affected by mental illness, the most common ones being schizophrenia and mood disorders and depressions. So there's something for you to think about in terms of your organization. While most people see disability in terms of accessibility, that is to say wheelchair ramps, grab bars, the physical things that you need to make your space more accessible. More often than not, people may not go on to think about these other forms of disabilities, the mental and psychological disabilities. This slide tells us about the terminology that we used. You remember earlier, a little while ago, I spoke about a person with a disability. This came about with the signing of the United Nations Conventions on the Rights of the Persons with Disability in 2004, which has been signed by Trinidad and Tobago and ratified. One of the things that came out of this convention was a shift in language. So, for example, we moved from the word disabled person to a person with disability. And, one may ask, well, really and truly, we're using the same words, you're just putting it in a different order. And yes, that is correct. The thinking behind it is that you see a person with a disability as first and foremost a person. You recognize a personhood in them, and you say they're a person with a disability as opposed to a disabled person. Now, one of the things also coming out of the United Nations CRPD is a concept known as reasonable accommodation. Reasonable accommodation refers to necessary and appropriate modifications and adjustments, not imposing a disproportionate or undue burden when needed to ensure that persons with disabilities ensure the enjoyment or exercise on an equal basis with all of the persons of fundamental rights and freedoms. What reasonable accommodation really speaks to is you as an employer taking steps to accommodate a person who has they have a disability. You are required to do what you can insofar as it does not impose a disproportionate or undue financial burden. So that if you're recruiting someone and they have a disability, you can't simply say, well, I cannot hire you. You have to look at, well, what can I do to accommodate this person? Similarly, if you have an existing employee and for whatever reason they develop a disability, and it is to remember disabilities aren't only physical disabilities. It could include medical disabilities as well. If they develop something like diabetes or high blood pressure or hypertension, heart disease, these sorts of things. These are also to be considered as disabilities, or cancer, or multiple sclerosis, anything that runs a gamut of these medical conditions. What can you do to accommodate that person? And these are just examples of what has been recommended in other places: adapting premises and equipment, adapting patterns of working time, and making physical adjustments to the premises, providing equipment, assistive technology, that sort of thing. We have the Equal Opportunity Commission has published guidelines for employers on disability in Trinidad and Tobago, and this is accessible on our website. And in the interest of time, I'm not going to go much into this area, but just to let you know that you can go to our website and get this document and read more as to what you can do in terms of reasonable accommodation. The next few slides go into general exceptions to what is provided for under the Equal Opportunity Act. I'm not going to, again, if you look at the last area, unjustifiable hardship in the case of disability, we had just spoken about that. I'm not going to go into these areas into too much detail again in the interest of time, but just to repeat that if you are interested in having us do a training session with your organization or your group, you can request that we do that, and we can come in and, well, again, I use the word come in, it's just a force of habit, but we can arrange to do that, whether we do it physically or whether we do it virtually. I had spoken earlier about victimization and offensive behavior. One of the exceptions under offensive behavior is that it does not apply to acts committed in a public place of worship. So if a person is standing up in the pulpit of a church, a mandir, a temple or a mosque, whatever they say would not be covered by offense, would not fall within the realm of offensive behavior. It doesn't mean it's acceptable. You will remember, I think about 10 years ago, an individual was charged for sedition for things that they said in a mosque in Lucarapa Road while preaching in their mosque. So if you are standing in your mosque and you slander somebody, you can be subject to civil lawsuits for libel and slander. You can be subjected to criminal charges for inciting a breach of the peace or sedition. What this section simply means is it is not something that the Equal Opportunity Commission can inquire into, because it was designed, that exception was really designed to recognize what is known as the freedom of religion principle, or your constitutional right, your right guaranteed under the Constitution, the freedom of religion, including the freedom of expression as to, so in other words, you should be free to say what are the tenets or beliefs of your religion. Again, as I said, we have our guidelines for employers that is available on our website. And the following slides just give you an example of what are some of the things that you should or should not be doing in terms of your recruitment practices. For example, if you look at the one in the middle, male employees needed for a plant shop. Now, it may be that the male employee is needed because that person was needed because of the physical work required to be done. They probably had to lift heavy palms and plants and heavy bags of soil and that sort of thing. But by itself, the ad would be discriminatory because you're saying a male person. What we would recommend in a now, of course, this is just not really classified that we to pull out, but what we would recommend in a situation like that is that you focus on the work to be done. So, for example, employee needed for heavy lifting, as opposed to a male employee, because you don't know, a female could possibly do it. I mean, when you put out that ad, it's possible that 10 out of 10 applications would be male, but at the same time, your ad by itself would not be discriminatory because you're saying that, you know, employee needed for heavy lifting as opposed to a male employee needed. So we said that ads should be as neutral as possible and focus on the requirements of the job. For example, if you look at one right, we have laborers wanted in and around Point Fortin, must have plea and Petrotrin Trinmar. Now, by itself, this could be discriminatory if you're saying the laborers have to be sourced from Point Fortin. On the other hand, if you look at the other ad, that's the security officers required for a company located in Carenage must have such and such. You say that the company is located in Carenage, but you didn't say you only want persons from, say, West, you know, Port of Spain and West, so the Western Peninsula. So a person who lives, again, going back to the example, Sangre Grande or Cuba or San Fernando would be free to apply. If they apply for the job, it would be up to the employer to say, well, you know, this is what we require of you. These are the requirements of your job, and this is what you're required to meet. Questions that you ask in a job interview. Again, if you check our guidelines for employers, you can find all of these questions. Do you have any disabilities? Now, sometimes persons say they want to ask this question because they need to know whether the person has any conditions that would prevent them from doing the job, which is a fair question. If you are hired to be a bus driver, then you need to have 20/20 vision. You know, you can't be partially blind or visually impaired, just using this example, and be hired as a bus driver. But we would recommend that you don't ask a question, do you have any disabilities? Instead, you focus on the requirements of the job. You can say, for example, you can tell them that this is the job of a bus driver. Do you have any visual impairments? We've had persons who have organizations located in the Point Fortin industrial estate who said that they need persons who don't present with any asthmatic conditions because of the work that they do. And again, you can ask that question as opposed to, do you have any disabilities? What do we do now? I think I know we have a few questions in the chat, so I think this would be a good point if you don't mind, if we can take some of the questions that we have. I must see, so yes, if you don't mind, let's look at some of the questions, and we can come back later on if we have a chance. Okay, where are these questions?
Do you want me to call them out for you, Mr. Granting?
No, sorry, I'm seeing them. Okay, thank you.
Okay,
Ms. Chase, so persons who are members of a union use this method to lodge a complaint. We have received complaints lodged by trade unions on behalf of members, but we deal with complainants on a one-on-one basis, meaning that even though the trade union might lodge a complaint, for example, we going into our processes, we will require the worker or the person who's affected to come in and, you know, for an interview and have discussions with us. In one situation we have going on right now, the union lodged a complaint and we can't seem to find the person at all to follow up with the matter. So that a union member can lodge a complaint, a person who's a union can do it on behalf of their member, but at the end of the day, for example, when we have to interview the person or have discussions with the person, we would need for that person to be there as opposed to just a union rep only. The union rep can accompany them if they wish, but it's not necessary that they do, but if they wish to do it, they can, but we would need to be able to meet with the person. Who determines the category the EOC will fall under? That is, if it is determined that the complainant has to determine that, will the commission determine that, or what type of issues presented using the complainant outlines? What the Act contemplates is that the person has to lodge a complaint and they should do it within 6 months of the act that they complain about. When they lodge a complaint, our staff would contact you and would try to discuss the matter with you so that even if your complaint form is, for want of a better word, incomplete, or you're unclear about something, you can still lodge a complaint with us, because our staff will contact you and try to schedule a meeting with you, and we'll discuss the matter further with you in the meeting. So it's it is not the same as if you're filing a matter in court, where you have to, as the lawyers will tell you, you have to cross your T's and dot your I's and that sort of thing. You know, you can bring your information to us, and we would probably try to sit with you and see how best we can work with your matter. Does the Act cover professional organizations? Does it extend to the wider Caribbean? I'll take the second question first. It does not extend to the wider Caribbean, because acts of, this is just something that applies to in all countries. Legislation passed in any country really applies to the territory of that country. So, for example, we can't really govern what a professional association in Jamaica or Barbados does. We have no jurisdiction over them. In terms of professional organizations, if you recall, when we looked at what are provisions of goods and services, we said that the services of any professional body or association or professional group or any profession, for example. So it would extend, just using this example, it would extend to the practices of attorneys at law, how they practice, and it would also extend to the Law Association for Antigua. I'm just using this as an example of professional organization. So yes, if the profession or how is a complaint made? Please advise me steps. You can go to our website. You have to, a complaint has to be in writing. We have complaint forms on our website, but you can also you can also lodge a complaint using our website process. In other words, we have boxes to click, you click next, and then you click submit. And that can be done at any time of the day or the night. You can download the forms from our website and print it and fill it out in pen and paper if you prefer to do that as well. But then you would have to, email it or fax it or drop it in. But whereas if you use, we tend to try to encourage people to use our website simply because if you just press click and send it and it goes. Is there a time frame for complaints to be submitted? Yes, it has to be done within 6 months of the alleged act. Who is the lead? Sorry, just to go back to that, it has to be done within 6 months. Now we have had we have recognized what is known as continuing breaches. That is to say, where breach continues on an ongoing basis, then it is said that with each day a new cause of action arises, but it has to be done within 6 months of the course of action, as a lawyer would say. Who is the liaison person of our company would like to request a training session? The liaison person is our Chief Executive Officer, Ms. Devanti Maraj Ramdeen. So if you don't remember the name, you can just write to the CEO, but as the Chief Executive Officer, you can write to her and request a training session, and they will follow up with you. Sorry, is it you can go up, please. I didn't see that, sir. Has there been an increase, decrease in complaints since the shutdown in response to COVID-19? Yes, yeah, there has. I think it's been fairly consistent. I can't say there's been an increase or a decrease. We actually have guidelines for employers on COVID-19. I didn't get to mention that, and I know time is almost up. So we have guidelines for employers on COVID-19, and that's also available on our website. So how employers should treat with persons coming out of the COVID-19 pandemic. But we have not really seen anything. I think there might have been an increase, but I have not seen a significant increase. Ms. Devika Sami, what about when employers do not use due process in a disciplinary proceedings? For example, not having a supervisor present in a meeting or demanding someone signs a letter without wrongdoing. Now that really does point to a lack of due process, but by itself, I'm just throwing this out to you, may not necessarily be discrimination under the Equal Opportunity Act. That might be an area, the area that I'm pointing out to might be behavior that is contrary to good industrial relations practices and principles, and that might be something for a trade union to address. But it may not be discrimination under the Equal Opportunity Act, because remember, discrimination has to be tied to a status ground. So going back to your example, if you can tie it to say that the employer did this to me, but did not do this to other employees who are for different race to me, or for different religion to me, or for different sex to me, then you can perhaps link it to a discriminatory characteristic. Or if you're saying your employer did to you as an act of victimization, that is, because I have proceedings going on against him in the Equal Opportunity Commission, they decide to, for whatever, they common language, they railroaded me like that, then that might be victimization of the Equal Opportunity Act. But just doing that by itself, unless you can tie it to that status ground or to victimization, by itself might just be a breach of industrial relations principles to be remedied by trade union. And I can't see the last one because it's beneath by my. Could somebody read it out for me? What kind of
what kind of redress can someone seek if they feel they were discriminated against under the guise of COVID-19?
Well, in terms of the kind of redress, as I had mentioned as briefly, I know I'm almost out of time. What we do, you bring people to the party, bring the parties to the table to conciliate. And if you are able to conciliation really speaks to having a discussion. If you're able to discuss it and reach a resolution, then whatever that resolution is between the two of you, it could be anything at all. It could be that they transfer you, they reinstate you. The conciliation is really between the employer and the employee. So we don't really go on to say what you can get. And so in terms of COVID-19, it really is depending on what you are claiming. For example, if you read our guidelines for employers on COVID-19, we talk about rostering persons for shifts. So that if you're saying that I was not rostered for shifts or I was not, or what have you, then the redress might be that you're looking to get yourself rostered again. Now, this is what if that's good conciliation. When it goes before the tribunal, there are courts, and I didn't get to go into this, but the court has given judgments where they've given audit compensation, and that what lawyers call damages is a legal term that lawyers use, damages, which is really compensation. So they've given substantial sums of compensation to someone. For example, one of the cases that actually made the front page of the newspaper was a security guard. This is a tribunal decision, who was fired because she started wearing a hijab. So she claimed that she was discriminated against on the basis of her religion. And the tribunal agreed with her that her wearing a hijab really was an outfit. And the persons from the security company tried to argue, well, we're not discriminating against her because she's a Muslim, we're discriminating against her because she's wearing a hijab. And the court agreed, no, that the wearing of it, some Muslim women choose to not wear hijab, and some Muslim women choose to do it. You remember I said earlier, it's not really for us to argue with you on your doctrinal beliefs. The wearing of a hijab is an outward manifestation of her religion, which, as I said, some women may do it, some women may not do it. And having chosen to do it, she was fired. So that was discrimination on the basis of her religion. And she received substantial damages, I think about $200,000 or thereabouts in damages from the court. Are there any other questions or anything anybody would like to ask?
Mr. Granting, I have someone sent me a question directly.
Okay.
They'd like to know if a company, so company X has a policy that they don't hire persons with, let's say, dreadlocks, and that's stated in their policy. Could that person then go to the EOC and file a complaint, or what? Yeah. Or will the company's policy protect them?
No, they can go to the EOC and file a complaint, and it will be for the company to be able to justify why they have this policy. And in cases emanating from other countries, if the company, for example, is a restaurant, and they say that you need to present yourself tidily because patrons may feel an untidy and unkempt waiter. I'm just using this as an example. But it's not good for our business. Then the company may have a defense if they can say that. So they would have to be able. So on the face of it, yes, the person can lodge a complaint, and the company would need to be able to justify why this policy exists. For example, in companies that work with heavy machinery, they tell you your hair needs to be tied back and pulled back and that sort of thing, and you can't have long hair because of the danger with moving parts. So again, the company would have to justify why their policy exists.
So what happens if the organization doesn't respond to the complaint?
Okay, if the organization doesn't respond to the complaint, we are empowered. So once a complaint is lodged with us, we can send a notice in writing to the employer to provide organization to provide information. If they do not respond, we are empowered under the Equal Opportunity Act to lodge, as they say in the local language, to bring them up before the magistrate's court. We lodge a complaint before the magistrate's court, and a summons is issued, and they're summoned to court. And they can be fined it is up to them to show that they have good reason for not complying. And if they are not able to show this, then they can be fined by the magistrate. And the fine is actually provided for Section 36 of the Equal Opportunity Act, It is a fine of $1,000 per day, or in the case of an individual, and $5,000 per day in the case of a body corporate for each and every day that they have failed or refused to comply. So we are given the power. So we can't issue the fine ourselves. Now, when you look at, for example, the Environmental Management Authority, they have a power to issue fines on their own. We can't fine the person ourselves. We have to take them to the magistrate's court for what is known as a summary offense. It is a summary offense, that is to say, non-compliance with us, and they can be fined by the magistrate. Okay, are there any other questions or anything anybody would like to ask? All right, I think there's an evaluation form somewhere in the chat. So if you do get a chance, we would appreciate if you could fill out the evaluation form. And as I indicated, you know, if you would like us to do our seminar, sorry, the form is not working. Okay, fine. thanks for telling us. Okay, I thought it was. I guess there's no evaluation form then. But
let me click it and see if it's working on my end, because I just copied and pasted it from the email I got.
Okay. Right, but as I said, if you would like us to do one of these seminars from our, in your organization, you're free to ask us. And as I said, write to our Chief Executive Officer. And, you know, in the past we did it personally, but I guess with COVID-19, we do it online. Is there a time limit on lodging a second complaint? Any complaint really has to be lodged within 6 months. So that if you're being victimized, then you would have 6 months in order to do it.
I'm just checking on my end again for the evaluation form, right? So I'll allow you all to stay on for 2 minutes. So if there's any other questions, please ask before we cut off. I think there were 1 or 2 things in the chat.
Okay,
not sure if you answered everything.
All right, sure. All right, yes, thank you very much. In fact, well, if there are no other questions, I guess, well, thank you for your time and attention. And we hope that, you know, you can contact us if you need. And apart from contacting us to do sessions like us, a lot of people sometimes they ring us and ask us for advice on matters. You know, we can, you know, discuss things over the phone. We didn't get to talk about sexual harassment as a form of sex-based discrimination, but sexual harassment is a form. And for example, a lot of organizations have asked us with help in reviewing their sexual harassment policy. So that's something we've been doing a lot of recently. So again, these are things that you're free to ask us to do.
Okay, so I got the form to work, so I'm resending it in the chat.
Okay, yes. All right.
Okay, so I'll keep the webinar on for another minute so that person can click the link and fill out the evaluation form.
Okay. Do you have an office specifically for Tobago? No, that is a bit of an issue with us. We have been using the Office of the Ombudsman, who has allowed us a day facility, for want of a better word. That is on Barclay Street in Scarborough, or right opposite the High Court. Well, the Tobago courts, the High Court and Magistrates Court are in one compound, and opposite to that, there's a building that has the Legal Aid Authority and the Ombudsman and a lot of public sector organizations. Now, prior to COVID-19, we used to go in, I think it was the 3rd Thursday of every month. It was so long ago, I can't remember. but because of so the last time we would have been there was really January or February, I think. And after that, we have not, well, obviously flights to Tobago and all of these sorts of things aren't really functional. So we have not resumed our Tobago operations. But that was what we used. We used the Office of the Ombudsman on the 3rd Thursday of every month in the past pre-COVID, where that was our Tobago office day. So persons were able to come in to speak to us and, you know, and chat with us, and we would be able to chat with people on that day. And well, at this point, I really can't say if and when that's going to, I mean, it has to be resumed at some point, but I can't really say when. But again, thank you all for your attention. And I'm sorry, there's one last question I'm seeing. Okay, I think we have to end, unfortunately. Okay, in terms of sexual harassment, I just want to talk to 30 seconds on this question. We always recommend that your first line of complaint should be with the organization itself. So if someone was sexually harassed in their job, the first line of complaint should be, yes, to speak to the Human Resource Department or someone who's designated. We have guidelines for employees on sexual harassment, so you can actually download. Those are the 3 guidelines was disability, employment, and sexual harassment. So you can read more about that there, about the types of investigative processes that should be followed. But we would say that your first line of complaint as in any IR issue or HR issue, should be with your organization. And if it is you're not getting a recourse, then you can come to us and lodge a complaint. And with that, I think, I know, yes, and I know you have to end, so thank you very much, everybody.